Good morning, everyone. I hope everyone's well this morning.
Morning, Your Honor. Good morning, everybody.
Good morning.
Let's see, it's right at 9 o'clock. Are we going to start with you, Officer Milton, today?
Yes, Your Honor. Thank you.
All right,
let's
go
be coming
ahead.
up. Position 16, Miss Octavia Lyman. Miss Lyman? I'm sorry, my bad. Ready. Sheila Owens, position 20 and 21. Miss Lyman, I'm going to bring her on the second rotation.
Okay. 20 and 21. Ms. Vigiletti, good morning. This is going to be a non-negotiated plea, is that right?
Yes, Your Honor, and if it's possible, I need to discuss with the court and the state some private matters. If it's possible to speak in a breakout room about this case.
Okay.
If it's possible to.
So who do you,
I'll just keep going, he'll always talk about this.
so you want a breakout room with courtroom 2, myself, and the solicitor on the matter?
You can't do that? You can't do that?
I'm sorry, Your Honor, I'm trying to work with the deputies as well to see if we can.
Okay, well, you all just let me know what you'd like for me to do.
Okay, Your Honor, I can bring Miss Owens back on the second rotation, but I would like to go ahead and get Miss McLeod's 2 clients out of the way.
Okay, Deputy, they're taking the other clients out of the courtroom, so we can handle Miss Owens.
Okay, thank you.
Thank you.
Okay, so who needs to go into the breakout room?
Good morning, Your Honor. I need to go in.
Yes, good morning, Mr. Esiano. And let's see. Ms. Champion, you're hosting today, is that right?
Yes, sir.
Thank you. So you'll place us in the breakout room, please.
Okay, it's going to be courtroom 2, and Miss Desiano, yourself, and Miss Grace in the breakout room only.
Yes, please.
Okay, thank you.
Yes, good morning, Ms. Owens. I'm Judge Eric Morrow. This is the state all-purpose calendar. We've had an opportunity to discuss your case. I'm going to reset your case until next Tuesday to allow your attorney some additional time to work on your case. So I will see you back on next Tuesday, ma'am. Have a good rest of your day. Anyone else in ACDC that we can take?
Yes, Your Honor. I have Ms. Attorney McLeod's two clients. Position number 9, Ms. Sharika Grady. And after that is add-on 2, Ms. Tracy Satterwhite.
Good morning, Ms. McLeod.
Good morning, Your Honor.
Have you had the opportunity to speak with Ms. Grady?
I did have an opportunity to speak with her, Your Honor, and I think her case needs to be taken up in a breakout room.
Okay.
I would
Uh,
rather we do Miss Satterfield first.
Okay. And let's see. Miss
Miss
is
Satterwhite.
position number 2 on the state all-purpose add-on calendar. What are we going to do with Ms. Satterwhite this morning, Ms. McLeod?
Your Honor, I have filed a motion for modification of bond in her case, and I would like to argue for signature bond for her.
Okay. Are you going to file a waiver of arraignment?
Yes, Your Honor, I will be doing that as well.
Good morning, Ms. Satterwhite. I am Judge Morrow. This is the state all-purpose calendar. You've been charged in case 24 CR 004035Y with reckless conduct. Let's see, who do we have on from pretrial this morning? I see you there, Mr. Ham. Good morning. Let me get her history first, and so that I have some baseline. Ms. Jackson, are you with me?
Just having problems unmuting, and I apologize to the courts.
Okay, you're fine.
thank you.
You're fine, Ms. Jackson. We're on
Okay.
Ms. Satterwhite, who is the add-on position number 2. Do you have her history for me?
Now, I'm about to pull it up, Your Honor. It's a lot of calendars. I apologize. But
Okay,
I'm
no,
about to pull it up right now.
okay, you do that. And Mr. Ham, can you tell, good morning. Can you tell me what the current bond is and what the reckless conduct involves?
One second, Your Honor, I can pull up the current bond, but I can tell you the reckless conduct involves the fact that the defendant in this case attempted to apparently shoot herself, and she grabbed the AK-47 and wind up shooting another person in his left arm.
Okay,
Your Honor, I do know what her bond is. It's a $5,000 good bond.
That's correct, Your Honor.
okay.
I have that record up if you're ready, Your Honor.
Yes, thank you, Ms. Jackson.
Okay. She has 13 cycles, Your Honor. The last arrest was June the 7th, 2023 in DeKalb County for reckless conduct. There is no disposition for that arrest. Just scrolling up, I do see a probation violation that was on the 15th, August the 20th, 2015 in Clayton County. The underlying charge says forgery in the first degree. Let's scroll up to see if I can find that. Okay, that was a first offender in Clayton County on August the 24th, 2010 for forgery in the first degree. The case was sealed on July the 6th, 2017. See if she has anything else. I do see a misdemeanor conviction that was in Fulton County in 2010 for fray. And I do see a disorderly conduct conviction in 2010 out of DeKalb County. I do see an additional misdemeanor conviction that was in 2004 out of Clayton County for interference with custody. And nothing in addition. Wait, just a minute here. I do see another misdemeanor conviction that was in 2003 out of Fulton County for 3 counts of disorderly conduct. This is on there. And battery, family violence. Nothing in addition, Your Honor.
Thank you. Yes, Ms. McLeod.
Yes, Your Honor, there are some very interesting and mitigating circumstances surrounding this case. My client has been in a very abusive relationship with a gentleman by the name of Mario Keene for approximately 23 years. They share a 17-year-old child. On March 12th of this year, Mr. Keene pled guilty to battery family violence against my client. When his plea was taken, and there is a recording of the SAP calendar on which his plea was taken. When this plea was taken, he was specifically instructed to have no further contact with my client and to stay away from her residence, which is the location that this particular incident with which she's now charged occurred. Apparently, Judge Law was reluctant to release him. It was a non-negotiated plea, Your Honor, because she said she was convinced, she was not convinced that he would be staying away from my client. Apparently, as soon as he got out of jail, he went back to the house, started harassing my client, giving her a hard time. She tried to call the police on more than one occasion. He knocked the phone out of her hand. On this particular occasion, she was at her wit's end because she just felt there's nothing else I can do to stop this man. And she grabbed a gun that apparently belonged to her son and tried to commit suicide. She was depressed. She was essentially having like a mental breakdown, and she just felt like nobody was helping her, and she just wanted to end it all. So she attempted to shoot herself because he was there at the house. He came there. An independent witness said that they heard loud arguments, and when they opened the door, they saw him tussling with her. Apparently, he was shot in the process in his bicep. It says this man was not supposed to be at her house. He was not supposed to have any contact whatsoever with her. This was from this year, Your Honor. And that is why she got arrested. Because she was just desperate. There was nobody to help her, and she tried to kill herself. I am asking for a signature bond for my client because she's not in a position, she is indigent, to pay for a bond to get out. I believe that she has a very good defense to this case, Your Honor. I have a copy of the video where he was sentenced, and when Judge Law specifically told him, and I filed a motion into the case with a copy of the disposition in that case where it was stated that he's not to have any further contact with her. And he is the alleged victim of this reckless conduct, Your Honor. I'm asking the court to consider giving my client a signature bond so she can get out of jail and properly defend against this charge. Nothing further, Your Honor.
Okay, where is she going if she gets
back to her home, Your Honor? He's not supposed to be at her home. The bond order says no further contact and needs to stay away from the address. She's been living at that address for the past 4 years. She has a 17-year-old daughter there right now that she is concerned about.
Okay.
He does not live there. He's not supposed to be there. And her name is the one, it's subsidized housing, and she's the only one who's supposed to be living there with her child.
Mr. Ham, do you have any input on this as far as what Ms. McLeod is telling me? Have you had the opportunity to investigate that with regards to the alleged victim in this case?
No, Your Honor, this is the first time that I've heard that story about.
I told Ms. Falk knows about it.
this is the first time I'm hearing that story about things that occurred between the victim and the defendant in this case. What I can say that the state's concern is, I understand that she was attempting to take her own life, but it could have very well have been someone else that would have shot other than him, such as her son. So that is the
Her
state's.
son was not there. I'm sorry, I did not mean to interrupt you.
That's the state's main concern, is the actions that she took could have harmed someone else other than the Mario King or herself. So that's the state's main concern in relation to her mom.
I understand the state's concern. If I do let her have a signature by Ms. McLeod, I'm going to require a mental health evaluation as part of that. Given what I've heard, and that you're an officer of the court, and you're very detailed about the circumstances with Ms. Satterwhite, I will convert the $5,000 good bond to a $20,000 signature bond through pretrial level 3. She is to have a mental health evaluation. She is to have, of course, no further contact with the alleged victim. That shouldn't be a problem, given that he's not supposed to be around her. And no drugs, alcohol, weapons. She'll have to surrender any weapons that she currently has.
Thank you, Your Honor. And we do want the mental health evaluation as well. My client actually requested that. So I'm glad that the court is ordering that because I forgot to mention it.
Okay. So that's what we'll do with Ms. Satterwhite this morning. Good luck to you, ma'am.
Thank you. Thank you.
And Ms. Satterwhite, if this gentleman comes around you at all in the future, you need to immediately call the police, and you need to immediately report it and make sure that it's documented. Okay?
Yes, sir.
If you even see him, you call the police.
Yes, sir.
Okay. Good luck to you, Ms. Satterwhite.
Thank you. Thank you, Your Honor.
Ms. McCall, it looks like we cannot do a breakout room because they have the oh, we don't need courtroom 2 for the breakout room. Okay, so we just need who's gonna go into the breakout room with us? This is on who do we have there at ACDC? Tell me again.
Position number 9, Sharika Grady.
Okay, so and Mr. Ham, is this your case? Okay, so Ms. McLeod, Mr. Ham, and myself can be placed into a breakout room, please.
You ready? Hi, are we gonna have the Spanish interpreter?
Good question. I reached out yesterday about it, but I haven't gotten a confirmation yet on whether that is possible.
Okay, what I'll do, I'll wait until the interpreter comes on before I bring him up.
Makes sense. And can I also, Deputy Milton, Octavia Lyman, if I could speak to her for just 1 minute when she comes down.
She's gonna be I don't have her up here right now,
Okay,
but as soon as I bring her up, I will call courtroom 2.
okay, great. Thank you. There's one little detail, just really quickly, I need to confirm with her. Thank you.
Okay, thanks. Do you need to speak to Ms. Shelton also? Because I'm bringing her also on the second rotation.
No, she's ready.
Okay, great. Thank you.
Officer Milton,
Yes, Your Honor.
we've had an opportunity to discuss Ms. Grady's case. Her case is going to be reset until August 22nd.
Okay.
Right. We'll see you back, Ms. Grady.
All right. Split up today. Oh, God, 5 through 10, might step on 4.
Okay, let's see. Courtroom 2, where would you like to go now?
Ms. McLean. Is Ms. McLeod still on?
Yeah, she's still on.
Yes, I'm here.
We can do her case, Mr. Grigsby.
Mr. Grigsby. Okay, I thought he was on the competency calendar.
Is he on the competency calendar?
I believe so.
Okay. No. Yeah. All right, we can go to one of Mr. McLean's client, Ms. McLean. Ms. McLean. We can go to position number 2. Oh, no, not position 2, position 3. Mr. Steve Dowie.
And this is going to be a waiver.
Yes, Your Honor.
And a bond modification request.
Yes, Your Honor.
Okay. Ms. Jackson, is there a history?
He has one prior cycle. The last arrest was October the 5th, 2014 in Virginia for larceny. Appears to have, I think that charge was amended. It was in 2015 out of Virginia. He does have that one misdemeanor conviction for theft by shoplifting. Nothing in addition, Your Honor.
Thank you. Mr. Ham, do you know what the current bond is and the circumstances?
1 second, Judge, I can get the current bond. But as far as the circumstances, this case happened on June 21st, 2024. Police were dispatched to 290 17th Street, Northwest, regarding a dispute call. The victim in this case had indicated that the defendant had taken items from her safe, including a firearm, and that early in the morning he had returned to her house and appeared to be high on drugs, screaming and shouting. He spit in her face and then fled the scene after she called 911.
Can someone tell me the current bond?
It is $1,500 surety, Your Honor.
Anything further, Mr. Ham?
Nothing further, Your Honor.
Mr. McLean?
Your Honor, given the allegations and the relative lack of record, we're asking the court to consider a signature bond. There is clarity and in terms of coming to court. He understands that he would have no contact whatsoever with that area or with this person while the case is pending.
Ms. Hyde is on the line and wishes to address the court. Now is your opportunity to do so.
Wait, can y'all hear me?
Yes, Ms. Hyde. I will need, if you would like to address the court, I'll need for you to raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, ma'am. What would you like to tell the court?
Yes, no contact with the suspect as well, but his sister is here. I really have nothing to say other than I want him to get help. That's it.
I appreciate you being here today, Ms.
Okay.
Hyde. Okay, given his lack of history, Mr. McLean, and especially lack of violent history, I'll convert the surety bond to a $5,000 signature bond through pretrial.
They just made it work. What?
You'll have to mute yourself for me, Ms. Hyde. Thank you. Through pretrial level 2, 1-day anger awareness, no further contact with Ms. Hyde. Stay away from the 290 17th Street address. No drugs, alcohol, or weapons while out on bond.
Very good, Your Honor. I'll prepare that. Thank you.
All right, good luck to you, sir. Who do we have next?
We got position number 4, Mr. Thaddeus Duffy.
And this is a negotiated plea.
Correct, Your Honor.
Yes, good morning, Mr. Duffy. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Yes.
Okay, can you raise your right hand for me?
No.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Yes? Okay, thank you, sir. Mr. Ham?
Yes, Your Honor. The defendant is charged with one count of criminal trespass. The state's recommendation for that count is 12 months to serve 44 days. Credit for the time served, which is 22 days. The balance to be served on probation, to stay away from 504 Hopkins Street in Atlanta, Georgia, and to have no further contact with Tamara Jones, and to take a mental health evaluation and any treatment deemed necessary. For count 2, loitering and prowling, the state's recommendation is 12 months probation to run concurrent with count 1.
I did put that down as a negotiated plea, but I did have a note here. It seems like the two counts would merge. Did the state consider whether the second count being at that same place? Does that look like a merger, y'all?
Not necessarily, but the state will just move the null process if there's any confusion.
Thank you.
Okay, so he's gonna plead to the one count of criminal trespass, and the loitering and prowling will be null process. Is that correct?
Yes, Judge.
Thank you.
Okay. Yes, anything further, Mr. McLean?
Nothing, Your Honor. He asked the court to accept his offer. The negotiated plea for the purposes of the plea stipulates to venue, factual basis and identification.
Mr. Duffy, it's my understanding that in case 24 CR 003966J, you wish to plead guilty to criminal trespass. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation?
Yeah.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? You don't want a jury trial, do you?
No.
Okay, you understand you have a right to one, and you're giving up that right by pleading guilty. You understand that?
Yeah.
Has anyone forced or coerced you to plead guilty?
No.
All right, Mr. Duffy, I'll accept the plea as negotiated. Let's see, as soon as you complete the mental health evaluation and any treatment, then I'm gonna have it go to a non-reporting status. So you'll still be on probation, but you won't have to report, okay?
Yeah.
All right, Mr. Duffy, good luck to you, sir.
Next, we can go to position number 6, Mr. Anthony Fambro.
Your Honor, on Zoom is Rosalind Chambliss for Mr. Fambro. That's his mother.
Okay, let's see, this is going to be a waiver and a request for a bond reduction.
Yes, Your Honor.
Correct?
That
Okay,
is correct.
all right, may I get his history, please?
He has 27 cycles. The last arrest was February the 14th, 2022 in Fulton County for aggravated assault and riot in a penal institution. Some of those charges may have been amended. I do see a misdemeanor conviction in 2023 for a fray for that arrest. He does have prior felony convictions, one in 2018 for possession of a firearm by a convicted felon, one in 2007 for aggravated assault and possession of a firearm during commission of a felony, and possession of cocaine with the intent to distribute. And he does have a misdemeanor conviction and a sentence. He received a nolo contendory sentence in 2018 out of Douglas County for driving while license suspended or revoked. And there was a conviction in 2018 out of Cobb County for a DUI. Nothing in addition, Your Honor.
Okay, thank you. What is the current bond?
$1,000 surety bond is current, Your Honor.
Is that split 500 for each charge?
On the booking sheet I printed out yesterday, it only shows just criminal trespass only as one count on the booking sheet.
If I may, Your Honor, he was given $1,000 SOP through the jail on the willful obstruction of a law enforcement officer, and $1,000 bond on the criminal trespass.
That's right. I see that.
Oh, okay, thank you.
That's under the detail page. Thank you.
All right, let's see, Mr. Ham, what are the circumstances?
Your Honor, the circumstances are on just June 21st. They got a call to a location where they arrived at that location at the Metro PCS store at 832 Ralph David Abernathy. The caller advised that there was a disturbance in the male refusing to leave. He stated that the male had a glass bottle, has a weapon inside the location. They asked the male to leave the location. He refused. They spoke with the manager, who indicated that they had issued, that he wanted him to have issued, or excuse me, he wanted the police to issue a criminal trespass, and that the male was not allowed at the location. When the police arrived, he was still holding a glass beer bottle in his hand. The police asked him to leave the location several times. He refused. And then at that point, he began to fight with the police officers as they tried to get him to leave the location. The officer was struck in the face with his elbow, with the defendant's elbow, and at that time they used a city-issued taser. He fell to the ground and they were able to arrest him. Your Honor, these facts, as well as the significant history, such as several aggravated assault convictions involving the use of a firearm, he is one of aggravated assault 06SC 48785. He has another aggravated assault conviction out of Fulton County, 12SC 112935. And a reckless conduct in possession of a firearm by a convicted felon out of Fulton County, 17SC 155271. Based upon these facts and his significant criminal history, and especially as it relates to violence and use of weapons, the state believes that his current bond is sufficient, and we ask that it not be modified.
Thank you. Mr. McLean?
Your Honor, we realize the bond is already where it is, and our request is simply to convert that to signature if possible. Because his family is on Zoom, they could just basically say, our main point in asking for a signature bond is simply that, given the charges, he's not going to be missing court. His family is going to make sure that he doesn't miss court. He's not been alleged to have failure to appear. And there should be no problem in his being at his trial.
Okay, and is this, who's on the line with us to speak?
His mother, Ms. Chambliss.
Okay, Ms. Chambliss, good morning, ma'am. If you can unmute yourself and raise your right hand for me, ma'am. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, Ms. Chambliss. What would you like to tell me about Mr. Fambrough and his situation?
He will go to court. He don't miss court. But I want him to have some mental evaluations. He during that time he had a meltdown. So I do want him to get some mental evaluation so he can move forward with his life in a positive way. He just needs some mental help.
Okay. And is he living with you, Ms. Chambliss?
With my daughter. With sister.
Okay.
Because I live in a high rise.
Okay. But that is where he's going to be staying with family.
Yes.
Okay. Thank you. Go ahead, Mr. McLean.
A mental health sorry to interrupt. A mental health evaluation would be appropriate to add to the conditions bond.
Okay, so that would be a part of the requested sentence. So given what I've heard this morning, I will convert the criminal trespass $1,000 good bond to a $3,000 signature bond through pretrial level 3. A mental health evaluation and a treatment if necessary. Stay away from the 832 Ralph David Abernathy address, and no drugs, alcohol, weapons while out on bond. All right. Good luck to you, Mr. Fambrough.
Thank you.
Your Honor, I apologize. What's the breakdown, please?
He already has an SOB through the jail for the willful obstruction. So the only other account was the criminal trespass. So that was the $3,000 signature bond through pretrial.
Thank you.
Next, we go to position.
And position number 1, Mr. Odom, Ms. McLeod, client.
Where is that?
And he's position 1 on the add-on calendar. Let's see, do we have Ms. McLeod with us? She might be interviewing some other clients right now if she's not on with us. I know.
I'm here, Your Honor. I'm sorry.
Okay. All right.
I
Thank
was
you.
having difficulty getting my camera to come on.
Okay, you're fine, Ms. McLeod. What are we doing with Mr. Odom this morning?
Your Honor, this will be a request to have Mr. Odom's bond modified to a signature bond.
File a waiver.
And yes, I will be filing a waiver as well, Your Honor.
Okay. May I get his history, Ms. Jackson?
He has 35 cycles. The last arrest was August the 30th, 2023 in Union City, Georgia, for criminal trespassing. There was no disposition for that arrest. He does have a history out of Alabama. There was one in 2000, a felony conviction in 2000 out of Alabama for assault in the 2nd degree. And one in 2000, I apologize for being out of order. One in 2009 out of Alabama associated with a CWAC. One in 1996 out of Alabama for theft by receiving stolen property. One in 1997 out of Alabama for dangerous drugs. Nothing in addition, Your Honor.
Okay, so aside from this criminal trespass in 2023, he hasn't had anything since 2009. Am I right about that? I'm sorry, you're on mute, Ms. Jackson.
I apologize, Your Honor. Yes, that's what was listed in the GCIC, Your Honor.
Okay, thank you. And what's his current bond?
It is $15,000 good bond, Your Honor.
Do we know how that's broken down?
It's $5,000 on each count. There are 3 counts: battery, family violence, cruelty to children. I believe 2 counts of cruelty to children.
Okay. Yes, Mr. Ham.
Yes, sir. So this case, Your Honor, is that on December 16, 2023, police were called to 6710 Shannon Parkway in Union City. Police were called to that scene where the defendant was accused of punching or striking Deja Smith in her face. This was done in presence of the 2 children, which is why there are 2 counts of cruelty to children.
Your Honor, as the state has stated, this incident allegedly happened on the 16th of December, 2023, when my client was staying with the mother of his, I believe the child was approximately 2 months old at the time, in an extended stay facility. And she also had a 10-year-old child who was staying with them. Apparently, the people in adjoining rooms heard some loud talking going on and called the police. The police didn't come at the same time because my client was arrested in approximately 2 or 3 weeks ago when he was in a car being driven by someone else, some of his co-workers. They were going on a work-related matter when they were pulled over by the police, who informed him that he had this warrant. So he was just recently arrested. He was not arrested at the time. Your Honor, I have spoken with my client. I have also spoken with his ex-wife, who is on the Zoom at the moment. His ex-wife provided me with some videos which he had shared with her and which I had just provided to the state, where it shows, I think, pretty clearly that the alleged victim was the primary aggressor, and my client was actually lying on a bed and she kept coming at him. She spat on him, she struck him. And on the videos that I have, it was very clear that she was the primary aggressor. They are no longer in a relationship, Your Honor. And the alleged victim herself, well, the adult victim is currently in ACDC on charges related to abuse of that child. The child is in DFACS custody. I have been told by my client's ex-wife that she's trying to get the child adopted right now, but it's some peculiar circumstances, Your Honor. And I believe that giving him a signature bond would allow him to come out of jail and properly defend against this charge. He really does not have any kind of resources to pay this bond. His boss reached out to me 2 days ago and spoke to me and informed me that if he gets out of jail, he will be able to get his job back.
Okay. Given that he only has the one criminal trespass in 2023 and nothing for a good little while before that, I think that the bond is excessive. So I will convert the good bonds to signature bonds through pretrial level 2. He's to abide by the rest of the conditions, no further contact and stay away, and no drugs, alcohol, or weapons while out on bond. So if you'll make those modifications, I'll get those signed and entered, Ms. McLeod.
Thank you, Your Honor.
All right, good luck to you, Mr. Ovens.
And Judge, the next person is Sidwell. Add on 3 and 4.
Judge, that's level 2, you said?
3
Yes,
and 4. Oh, I'm sorry.
5,000 each.
Yes, just convert whatever the good bonds are to signature bonds.
That's you, Mr. McLean.
Okay, I'm sorry. Tell me again, Medical, who we have.
3 and 4 on the add-on calendar, Mr. Sidwell. This is Ms. McLeod client.
Negotiate, please.
Good morning, Mr. Sidwell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you hear me, sir? Yes? Okay, can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Yes? Okay. You have to speak up for me a little bit, Mr. Sidwell, okay? Thank you, sir. Yes, Mr. Hale.
Yes, Your Honor, for this whole count of criminal trespass on position 3, the state's recommendation is time served. He's been in custody for 204 days. For position 4, failure to appear, the state will move to null process.
Okay. Mr. McLean?
For the purposes of the plea, we stipulate to venue and factual basis identification. We ask the court to accept that plea.
Okay. Mr. Sidwell, it's my understanding that in case 23 CR 0069999Y, you wish to plead guilty to criminal trespass, is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
Not at all.
Okay. You understand, let's see, you've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced you or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Sidwell. Good luck to you, sir. You're welcome.
Next, we're gonna go to position number 11, Mr. Jeffrey Harper.
And this is also going to be a waiver with the bond modification request.
It is.
Okay, I I see that it's a possible DA transfer. Where are we with that, Mr. Hammond?
We submitted that. We're just waiting for approval for it to be transferred to the DA's office from the DA.
Okay. Given that, Mr. McLean, I think it's best for me to hold off on this. If you want to place him back on the SAP calendar, if he's not transferred on Tuesday, I'm willing to consider a bond modification at that time. Otherwise, I'll let them argue that in Superior Court.
Understood, Your Honor. Yes, as soon as possible, if we could check on that on an SAP. My client suffers from certain disabilities, and we'll talk with the state about those.
Okay, so I'm on this SAP calendar on next Tuesday, which is the 16th. If we can put that this case on that calendar, if it's not transferred, and at that time, if you choose to, I'll consider a bond modification.
Thank you.
Okay. Good luck to you, Mr. Harper. Ms. Rockwell, are you with me?
Yes, Judge. Thank you for holding for me. I'm sorry. I'm zooming all over the place.
Okay, I just saw you on there and I didn't know who you're representing this morning, so I wanted to see if we can get you in here. Who are you representing?
Thank you, Judge. My client is Quatez Elliott, and I apologize for emailing you and Judge Law and Ms. Githia, who's probably not even on the case, and Michael Jordan this morning. I just realized I hadn't notified y'all of my felony Zoom plea. I have Quatez Elliott, Judge. He is on today, and he's also in the Department of Corrections. So I don't know if maybe the prosecutor could suggest, or maybe Mr. McLean suggest what my next request should be on him.
So we don't have him before us today, is that right?
That's correct, Judge. I could get with Mr. Jordan just to figure out what the next move is. He's not going to be in the Department of Corrections for a long time, but he will be back in the Fulton County Jail when he comes back. I'm not sure why they do that.
Okay. So do you want to get with Mr. Jordan at a later time, Ms. Rockwell, and if we'll take him off this calendar, and if you want him placed on a future SAP calendar when he gets back, we'll do that. Is that okay with you?
Thank you so much. Thank you so much, Judge. Just briefly, who is my prosecutor going to be?
Ms. Rockwell, it's me. If you want to reach out to me, I'll let you know what the offer is, and if he can handle it while he's in custody, he may not be able to. He may not have to come back here. So
okay, good. I've got all his numbers, Judge. I got him. Okay. Y'all have a good weekend, Judge, and thank you so much for the platform. It's very appreciated when you're ripping and running, Judge. Thank you so much. May I be excused?
Yes, have a good day, Ms. Rockwell.
Position number 7, Fleming, Olajuwon.
Maybe?
Yeah.
That one.
Mr. McLean, this is also going to be a waiver with a bond modification request.
Yes, Your Honor.
Okay, Ms. Jackson, do you have Mr. Fleming's history for me?
Yes, Your Honor. He has 15 cycles. The last arrest was December the 22nd, 2023 with the City of Atlanta Police Department for possession of Schedule II controlled substance and possession of marijuana with the intent to distribute, and driving while license suspended or revoked, and affixing material to the window or window shield. There was no disposition for that arrest. He does appear to have an outstanding hold out of Conyers, Georgia for trafficking cocaine. The date on that warrant was January the 3rd, 2024. And he does appear, well, he received first offender treatment out of DeKalb County in 2021 for 2 counts of entering an automobile. That case was sealed May the 19th, 2024. He does have misdemeanor convictions, one in 2019 for obstruction of an officer. It's an additional one in 2019 out of Harris County, Georgia, for obstruction of an officer and fleeing or attempting to elude an officer. Nothing in addition, Your Honor.
Thank you. Mr. Ham?
Yes, Judge. The facts of this case are as follows. On June 19, 2024, police attempted to conduct a traffic stop at 2015, on a 2015 Dodge Durango for failure to signal. As the vehicle pulled into the CVS, the vehicle began to accelerate at a high speed. It proceeded to flee east on Martin Luther King. The police gave chase to the vehicle. They deployed stop sticks and made a positive connection with his tires. However, he still got away. He was able to make it onto I-20 West, and the vehicle continued to flee and disobey several traffic laws. Police were able to get a visualization of the vehicle. That's when it veered off into the embankment and crashed into several trees. Officers began to approach the vehicle. At that time, the defendant fled on foot. The officers gave chase, and they found him approximately 50 feet from where the vehicle was abandoned, hiding in the bushes. They placed him on arrest. At that time, the defendant indicated he ran because he had warrants out for his arrest. Police were able to identify several things that were thrown out of the vehicle. As the police chase pursued, they recovered a clear sandwich bag with approximately 8.2 grams of unknown bluish substance, which may indicate that at some point this may be transferred up to felony division once they're able to identify what that blue substance was and if it was indeed narcotics. So based upon his history, I apologize. As they searched the vehicle, they were also able to obtain a handgun in the center console that the defendant said belonged to him. So based upon everything that occurred in this particular incident, we believe that his current $8,000 cash bond is appropriate, given his history and the incident.
Thank you. Mr. McClain?
Your Honor, I noted and asked about and found out Jonathan Melnick is going to be hired by the family later. He's busy in hearings in a trial right now or in the trial itself and was not available for this morning's session. And so I'd just like to point out about the $8,000 cash bond, Your Honor, that if Your Honor could convert that to a surety bond instead of cash bond, even if we went up on the amount from 8,000 to 16,000, double it or triple it to 24, he would be better able to make that bond. His family does support him in these matters, and we'll make sure that he comes to court. We just feel that the $8,000 cash bond is impossible to make. Your Honor, let's see, that's all. I believe his family may be on Zoom.
Well, I'll just say that given the circumstances, Judge Law saw fit to give him that bond. I don't see any change of circumstances regarding that. I'm not willing to modify it. I'll let him seek a modification if he chooses to do so with the division judge when it gets there.
I'll communicate that, Your Honor, to the appropriate parties. And I appreciate the last point in particular because I didn't want to just barge in on a case which is about to be private counsel and preclude that private counsel from a certain time period before which he could make another bond argument by just coming here on an SAP with as little as we have because of our scheduling, isn't it?
I understand, Mr. McClain. I just feel if that's going to happen, let the judge that's going to handle it from here on out deal with a modification.
Thank you.
All right. Good luck to you, Mr. Fleming.
God. Next, we can go to submission number 11. No, not 11, Your Honor. Position number 8, Mr. Dominique Gay.
Okay. And this is going to be a non-negotiated plea. Is that right?
Yes, Your Honor, it is.
I take it what's not negotiated about it is a time in custody.
Yes, Your Honor.
Okay. May I get his history, please, Ms. Jackson?
Is this position 8, Your Honor?
Yes, it is.
Right. He has 13 cycles. The last arrest was April the 20th, 2024 in East Point, Georgia for criminal trespassing. There was no disposition for that arrest. He does appear to be on first offender probation in Fulton County. The case number is 23 SC 190-550 for entering an automobile. That disposition date was October the 27th. 2023, and the term is for 2 years. Nothing in addition.
Okay. Yes, Mr. Ham.
Your Honor, the state's recommendation is 12 months to serve 60 days, credit for time served, 21 days, balance suspended, and to stay away from the Sitco located at 2000 Delow Drive Southwest. Your Honor, we would like to bring to the court's attention that he was also issued a criminal trespass from this exact location under case number 24 CR 002108J on May 7th, 2024, where he was ordered to stay away from that exact same location. So once he was released from custody, he went back to that location, Your Honor, and picked up another criminal trespass warrant, another criminal trespass case. So based upon his reluctance to stay away from this location, the state is recommending additional jail time.
Is that case still pending?
No, Your Honor, he pled guilty and was ordered to stay away from that location on May 7th.
Oh, okay. Okay. And do you know what the sentence was for the previous case?
Bring it up. I believe it was essentially a time served plea and balance suspended and to stay away from that location.
I'd like to know how much time he served on that at that time, if you can get that for me. And while you do that, Mr. Ham, Mr. McClain.
Your Honor, I know this looks bad for Mr. Gay. I would like to point out that he is a very young man. We had quite a discussion about the concept of graduated increases in consequences when these things occur. He does have a job sweeping up and taking out the trash from the neighborhood market, which is next door. So we had quite a discussion about exactly where a boundary line would be if you took a bucket of paint and a brush and painted the boundary line between one store and the other. They're next door to each other. He gets about $10 or $15 per session when he sweeps up and takes out the trash for the gentleman who runs the neighborhood market. He did have money on him. I did ask him about that. He wasn't over there to cause a ruckus or to shoplift or anything like that. He had cash on him. And if he had been intending to buy a pack of crackers, that pack of crackers was going to cost less than the $2. So he wasn't trying to do anything morally wrong. The breaking of the previous promise is the problem, and he realizes the seriousness of it. So I'd like to ask the court to consider giving him time served on the jail portion of today's sentence and whatever else in the way of conditions the court feels appropriate.
Your Honor, he served 36 days in custody.
So we can't go backwards, Mr. McClain. You understand that? I think if he served 36 days, I can't give him 21 days for a subsequent offense where he, violated his probation.
We did have that discussion, Your Honor. Yes, we did.
So, I mean, I just, and I'd rather he get this over sooner than later. So what I will do is I'm going to accept the recommendation. He's going to have that stay away. I will have it go non-reporting upon
It is balanced. It's balanced.
Yeah, balance will be suspended, but he's going to have to stay away.
Yes, Your Honor. Let me ask him for a moment. If I might mute for just a moment.
Okay.
You understand what the judge? We're back off mute, Your Honor. Thank you. He will stick with the plea.
Okay. Anything further before I take the plea, Mr. McLean?
Nothing, Your Honor. Thank you.
Okay. Mr. Gay, it's my understanding that in case 24 CR 004063B, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Gay. Good luck to you, sir.
Probation's 9 and 10, Ricky Williams.
Ms. McLeod had asked, requested if her two clients can go next.
All right.
Okay, so where are we going?
We can go to position number 12, Mr. Ivy.
What are we doing with Mr. Ivy this morning, Ms. McLeod?
Your Honor, Mr. Ivy, I will file a waiver of arraignment on his behalf. It will not be a plea. He's going to need to go to trial.
Okay. Mr. Ivy, good morning. Your case will be returned to the division judge, and you'll get notification of your next hearing date, sir.
She told me I was gonna be free today, Miss. May I speak with him? Ma'am.
Your Honor, let me speak to him again because I believe he misunderstood what I said.
Yeah.
Okay, we can go to position number 10 while he
Just all
steps to
believe
the
it.
side.
Okay.
Okay, that's Mr. Grover.
Yes.
And what are we going to do with Mr. Grover, Ms. McLeod?
It's going to be a negotiated plea, Your Honor.
Okay, good morning, Mr. Grover.
Morning.
I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can place your hand down. Thank you, Mr. Grover. Yes, Mr. Ham.
Mr. Honor, the defendant is charged with simple battery family violence. The state's recommendation is 12 months to serve 30 days, credit for time served, 15 days, balance on probation, to stay away from 1510 Murphy Avenue Southwest, to have no further contact with Lakia Murray, to take the Venue Violence Intervention Program, and to have no firearm.
Your Honor, that is our understanding of the terms of the plea, and we stipulate to venue for purposes of this plea. My client actually lives in Alabama. He was visiting Atlanta. So we would ask if his probation could be, if he could report via telephone, because he lives in Tuskegee, Alabama.
I don't live in Alabama. He said he doesn't live in Alabama, Ms. McLeod.
I live right here in Georgia. But he live along.
Okay, so there won't be an issue with reporting then. Okay.
Let me get that straight.
So, Mr. Grover, it's my understanding that in case 24 CR 004190D, you wish to plead guilty to simple battery family violence. Is that correct?
No.
Okay. Looks like you need to speak back with him again, Ms. McLeod.
Your Honor, who we doing?
That's not my client.
Oh,
Who we doing right now?
We're doing.
Grover.
Grover?
Yes.
Now, this is Grover. We gotta get him straight now.
So this is Mr. Grover?
Yes.
That is not
Okay.
the person I spoke with.
I don't live in Alabama.
Okay.
I don't live in Alabama.
Okay. So apparently you might have spoken with the wrong person, Ms. McLeod. I'm not sure, but do you want to speak? Let's have you speak with both those gentlemen again.
I think that would be a good idea, Your Honor.
Okay, thank you. All right, so we could go back to medical.
Probation 9 and 10.
Okay.
Williams.
Good morning, Mr. Williams. I'm Judge Eric Morrow. This is a probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Yes, good morning, Officer Allen.
Good morning, Your Honor. The defendant was sentenced to probation for obstruction of an officer, possession of use of drug-related objects, and public indecency. He was required to do a sexual deviancy course as well as stay away from 232 Forsyth Street. At this moment, the defendant has failed to report to our office. He's failed to provide documentation of the sexual deviancy course. Your Honor, he has been in custody since May 8th, 2024 on new charges. It is 225 days remaining on his case.
And probation's recommendation?
Revoke 60 days and close his case.
Ms. Vigiletti?
Your Honor, Mr. Williams has been in custody for 65 days. And so, we just ask that you accept the recommendation of probation and we can close this matter.
So what was the problem with, I don't like just closing cases is there a reason that he did not comply with what he said that he was going to get done?
Your Honor, Mr. Williams has significant diagnoses. He does have a new open case, as Officer Allen discussed, and we are working with social work to try to come up with a better solution for resolving the next case.
Okay, so there is a reason.
Yes, Your Honor.
Okay, so with that said, I will accept the recommendation of probation. Good luck to you, Mr. Williams.
Thank you, Your Honor.
Okay, is there someone that we can take next?
Sorry, Your Honor, my clients are in the courtroom.
Okay, and just.
Your Honor, I don't know. Mr. Grover was the person that I spoke to. Mr. Grover, Danny Grover. I don't know if that was a person sitting in front of the court at the time, because of course I didn't see him. I just spoke to him on the phone. So I don't know that it's Danny Grover.
And I think he did confirm that he is the person who was present for that hearing. I believe we have a different identity issue that the officer is sorting out right now for a previous client, but.
And I just called you, Ms. McLeod, so you can speak with them again.
The Mr. Grover that I spoke to lives in Alabama and gave me an address in Alabama.
Mr. Ivy is saying he lives in Alabama, but I was calling you, Ms. McLeod, so you could speak with your clients again.
Okay.
So do you think that you were speaking with,
It could be that when they identified them differently, Your Honor. That could be the mix.
so they might be switched around?
Yes,
Okay.
that is possible.
Okay, so I'll let you clarify that and
Yes.
you all just be ready. Can we go to ACDC while we do?
Yes, Your Honor. Position 16, Octavia Lyman.
Hey, how you doing, Your
You
Honor?
still need additional discussion with her, Ms. Vigiletti?
We have spoken, Your Honor.
Okay, this is also going to be a waiver with a bond modification request.
Yes, Judge.
Good morning, Ms. Lyman. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video this morning.
Good morning, Your Honor.
Good morning, ma'am. Let's see, Ms. Jackson, is there a history for Ms. Lyman, position number 16?
Yes, Your Honor. My system is moving a little slow. Okay. She has 27 cycles. The last arrest was March the 8th, 2023 in Fulton County for a probation violation. The underlying charge was not listed. Still scrolling up. Let's see what's going on. See a failure to appear that was in 2021. I do see a probation violation. Hopefully I'm getting to that conviction. It was in 2021. Just to let the courts know, I'm still scrolling through the GCIC.
Then what happened is that Mr. Grover is
While she does, can we mute courtroom 2 because I can hear Ms. McLeod speaking with her client.
Okay, I do see that felony conviction that was in 2018 in Fulton County for assailing, opposing, or resisting an officer of the law in a penal institution. Still scrolling through it, Your Honor. You see a felony conviction that was in 2015-17 out of Fulton County for aggravated assault. I see an additional felony conviction that was in 2016 out of Fulton County for theft by taking. Still scrolling through the GCIC. See a misdemeanor conviction that was in 2015 out of DeKalb County for criminal trespassing. See an additional misdemeanor conviction that was in 2014 out of Fulton County for battery. And I do see a felony conviction that was in 2011 out of DeKalb County for criminal damage to property in the second degree and interference with government property.
Okay, thank you, Ms.
Definitely
Jackson.
this one.
Okay. What's the current bond?
Your Honor, I'm sorry, are we on, I just had to log back in. Are we on Lyman?
Yes, Ms. Desiano.
Okay, and this is a bond request, correct?
Yes,
Okay,
modification.
the bond in this case, Judge, was a $1,500 split bond. There's a $500 good bond on the terroristic threats and then a $1,000 SOB jail on the obstruction. And Your Honor, this incident occurred on June 28th, 2024 at 680 Rock Street, Northwest in Atlanta. The victim, Andrew Grober, stated that he had come home from the gym. He parked his vehicle. He saw a female walking around. They had intercourse. He paid her $50. She demanded more money. There was an altercation over the money. The defendant grabbed a knife and threatened him with the knife. The back and forth over the money kept happening. She dropped the knife at one point, and then she picked the knife up and threatened him again with the knife. When the officers detained and arrested the defendant, she walked away from police after they commanded her to stop, and then she actively resisted arrest. I assume the bond request is on the terroristic threats, the $500 good bond. Given her history, Your Honor, the state would object to that. I think a $500 good bond is low, considering that she threatened him with a knife. She's got 28 cycles in her arrest history. She has violent convictions for aggravated assault and battery. The bond is already low, and the state would ask that you keep it at 500.
Okay, Ms. Vigiletti.
Thank you, Judge. So I went back and I watched the first appearance that Ms. Lyman had before Judge Law to try to understand, because I agree the bond is low, why Judge Law said it this way. And Judge Law did state at that hearing that the reason she didn't give Ms. Lyman signature bonds on both cases is because Ms. Lyman did not have an address to provide pretrial services. And so she set the 500 surety on the terroristic threats and acts for that reason. I spoke with Ms. Lyman, and she does have an address she can provide the court. And I can give that to the court. I'll put it in the chat. It's her aunt's address. Ms. Lyman does have 5 kids. Her oldest is 27, but her youngest is only 8 years old. And the 8-year-old is staying with her aunt. She also has a 2-year-old grandchild. So she does have pretty significant domestic labor requirements, domestic responsibilities at home that she would like to get back to. I understand she does have a criminal history here, but it has been, I believe it sounded like 6 years since her last violent conviction. 2018, I believe, was the aggravated assault. She has no reason to have any further contact with Mr. Grober or go back to that address. They don't have a personal relationship. I'm sure she's happy to comply with any stay away requirements. And has every incentive to show up for court for this and get this taken care of.
Who's she going to be staying with, Ms. Vigiletti?
Her aunt, I believe it was a little loud over the phone this morning. I believe she said her name was Wilhelmine, and the address is 524 Joseph E. Food. And that is where her 8-year-old child is right now, Your Honor.
Okay, so if you'll put the address in the chat, I'll require that she stay at that address as part of the bond. I'll convert the $500 good bond to a $5,000 SOB through the jail. Okay, a $5,000 SOB through the jail with the requirements that are already on the other bond, and also that she stay at the address that you're going to place into the chat for us. Okay, Ms. Lyman, I'm giving you the opportunity to sign yourself out, but if you don't show up for your next hearing, they're going to put a warrant out for you, okay? And you'll be right back in the same place that you're in, so.
I promise I'll be there with bells on, sir, Jordan. Thank you so much. You have a blessed day. Thank you too, lawyer. I love y'all. You have a blessed day.
You as well.
All right. We can go back to position number 2, Mr. Grover.
Okay, so have we
Grover.
We have sorted out the issue, Your Honor.
Very good. So let's just start at the beginning again. What are we doing with Mr. Grover this morning?
Mr. Grover needs to have a date set for his hearing.
Okay,
I
so you're
will
gonna
file a
file.
waiver of arraignment, Your Honor.
Okay. Mr. Grover, your case is going to be returned to the division judge and you'll get notification of your next hearing date, sir.
What I'm saying is, they were saying something about being locked up in DeKalb County. I've never been locked up in DeKalb County.
Okay, well, they'll sort that out before your next hearing date, okay?
I don't have a bond or nothing now.
You do have a bond. I'm
I've been
not
here
sure what,
14 days. I've been here 14 days.
okay,
And
you do have a,
I can't make a cash bond. I can't make a cash bond.
I don't know what your bond is, sir. What's it, does anyone
Your
know what
Honor,
the
he
bond?
has a $3,000 cash bond.
Okay, well, I did
Cannot
not
make
hear.
He cannot make the cash bond, Your Honor.
I can't make a cash bond.
And I believe he told me that the bond was set by you, so I didn't see. I'm not sure, but that's what I was told. I haven't seen it, and I figured since you set it, there was no point in me trying to get it changed.
Okay, well, let's just see, because I very rarely set a cash bond. So if I set a cash bond, there must have been a reason that I did that. And so if it's my bond and I set a cash bond, I wouldn't, it would be out of the norm for me, I'll just say. Can
I don't
anybody?
know if it's your bond, Your Honor. I didn't have a chance to see the bond.
Excuse me, Judge, it was set by Judge Mincy.
Okay, so I very rarely set a cash bond, so, but with that said, I have not heard a request for a modification. Is there a request for a modification?
Yes, Your Honor, there is a request for a modification of his bond.
Let's just let's start from the top then. Ms. Jackson, is there a history?
And this is for Mr. Grover, correct, Your Honor?
Yes.
He has 37 cycles. The last arrest was January the 2nd, 2021, with the City of Atlanta Police Department for aggravated assault. That charge was null pros on January the 9th, 2023. He does have prior felony convictions, one in 2010 for possession of cocaine with the intent to distribute, one in 2003 for possession of controlled substance with the intent to distribute, one in 1996 for the violation of the Georgia Controlled Substance Act, one in 1992 for possession of controlled substance, and he does have misdemeanor convictions, one in 2019 for discharge of a firearm and disorderly conduct, and one in 2009 for disorderly conduct, and one in 2007 for dangerous drugs, one in 2005 for theft by receiving stolen property, an additional one in 2005 for 2 counts of simple battery. Nothing in addition.
Okay, I'm sorry, Ms. Jackson. Just so I'm clear, the 2021 aggravated assault was null pros, and before that, it was a 2019 discharge of a firearm.
That was a misdemeanor conviction, yes, Your Honor.
Okay, and nothing, only those 2 since 2019.
Yes, sir, Your Honor.
Okay. Yes, Mr. Ham, what are the facts of this circumstance?
Yes, Your Honor. Police were dispatched on June 9th, 2020. On June 19th, 2024 to 1510 Murphy Avenue in reference to a dispute. They were met by a woman who was the victim in this case, said that she had been away from her residence for a few days and she returned, that her boyfriend, the defendant in this case, was present. He confronted her about not being home and that he slapped her in the face and kicked her out of the place, out of their apartment. And when police were arrived, they were able to take pictures of the victim's picture.
Your Honor.
Is that it?
Yes, Your Honor, that's it.
Oh, I'm sorry. Okay, Mr. Hem, I was waiting on more. Go ahead, Ms. McLeod.
Your Honor, my client denies the allegations as stated in the accusation. He tells me that he is actually 68 years old. He tells me that he shares 2 children, they're adult children, with the alleged victim, but they have not been in a relationship for many years. He is legally blind, and she sometimes comes over and helps him out. And he denies that he struck her on this occasion. But he said she calls the police because sometimes when she's off her medication, she has issues and she has attacked him from time to time. He doesn't really have any history of domestic violence or anything, Your Honor, and he is 68 years old. He is in no position to pay a cash bond. So that's why he's been sitting in jail all that time. So I would ask the court to consider giving him a signature bond. Just given his history, I was unaware of his history also. That was something I did not know because I did not represent him in his initial hearing. But it sounds to me, based on what I have heard, that it would not be unreasonable for him to get a signature bond. He does live in Atlanta and has lived here all his life.
Okay. I agree with you, Ms. McLeod. I think a cash bond is excessive. I'm going to modify the bond to a $5,000 signature bond through pretrial level 2. No further contact with Ms. Murray. Stay away from the incident location. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Okay. So, Mr. Grover, I'm gonna give you a signature bond in this matter, but you're gonna have to make sure that you come to court to answer for the charges at a later date, okay?
Yes, sir. Thank
All
you.
right. Good luck to you, Mr. Grover.
Position 17 on Mr. Mays.
And I also have Mr. Ivy, if he's available.
Yes, he is. Position 12.
Yes.
Okay, and we sorted that out.
We have, Your Honor. Mr. Ivy lives in Alabama.
Okay, and what are we doing with Mr. Ivy today?
It is going to be a negotiated plea, Your Honor.
Okay, very good. Okay, yes, good morning again, Mr. Ivy. I'm not sure if I went through this with you before, but let me just do it again to make sure. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Did we have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir, yes, sir.
Okay, you can place your hand down. Thank you, Mr. Ivy. Yes, Mr. Ham.
Yes, Your Honor, for the count of simple battery, the state's recommendation is 12 months to serve 42 days, credit for the time served 21 days, balance to be served on probation, to stay away from 3724 Martin Luther King Jr. Drive, to have no further contact with Letitia Wooten, and also to take a 12-week anger management class. As it relates to the count willful obstruction of a law enforcement officer, the state's recommendation is 12 months probation to run concurrent with count 1 and to pay a $300 fine.
That is our understanding of the terms of the plea, Your Honor. And as I stated before, my client lives in Alabama. I have a good address for him in Tuskegee, Alabama, and a contact phone number for probation. And then we would ask that he be allowed to report to probation electronically because he lives out of state.
Fine with the court. Mr. Ivy, it's my understanding that in case 24 CR 004064J, you wish to plead guilty to simple battery and willful obstruction of law enforcement officers. Is that correct?
Sir, yes, sir.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with her representation?
Sir, yes, sir, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Mr. Ivy, let's see. When you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't have to be on active report to probation, okay?
Sir, yes, sir.
All right. Good luck to you, Mr. Ivy.
Thank you, sir.
Number 17, Mays.
That concludes my business before the court. Right. No,
Yes.
yes. Thank you.
Thank you, Ms. McLeod. Have a good rest of your day.
Thank you, Your Honor. You do the same.
Thank you. Position number 17, Ms. Vigiletti, again, this is going to be a waiver and a bond modification request.
Yes, Your Honor. And if I may very briefly, I'm just seeing the chat that Leroy Owens is on the call, and we have already addressed Ms. Owens' case. Mr. Owens, I've left you a voicemail, so if you could give me a call back, we can talk about Ms. Owens after court, okay? Because she's already gone. I just want to, since her family is waiting on Zoom and we've already addressed her case, I just wanted to put that out there.
Yes, I'll have them give you a call.
Okay, thank you.
Thank you.
Okay, sorry about that, Your Honor. Yes, position 17, Mr. Mays would like to enter a not guilty plea this morning. I'm happy to file a waiver of his arraignment, and we do have a bond request, Your Honor.
Okay, Ms. Jackson, Mr. Mays, is there a history?
He has 50 cycles. The last arrest was August the 31st, 2023 in Douglas County for a probation violation. He does appear to have open probation cases pending, one in Douglas County for forgery in the first degree. That disposition date was January the 13th, 2020, and the term is for 8 years. And he appears to have an open probation case pending in Fulton County. That case number is 18 SC 163538 for aggravated assault. That disposition date was February the 11th, 2020, and the term is for 5 years. He does have a prior felony conviction that was in 2016 out of DeKalb County for identity theft, fraud, and forgery in the first degree. He does have misdemeanor convictions, one in 2022 out of Douglas County for simple battery, one in 2019 out of Cumming, Georgia for theft by shoplifting, one in 2018 for afraid and disorderly conduct, one in 2017 out of Clayton County for 2 counts of cruelty to children in the 3rd degree, one in 2016 for forgery in the 4th degree, an additional one in 2016 out of Douglas County for forgery in the 4th degree. There was another one in 2016 out of Cobb County for forgery in the 4th degree, one in 2015 out of DeKalb County for forgery in the 4th degree, one in 2012 out of DeKalb County for simple battery. Nothing in addition, Your Honor.
Thank you, Ms. Jackson. What's the current bond?
The current bond, Your Honor, is Judge Williams ordered a $2,000 split bond. It's a $1,000 SOB jail on the theft by receiving and a $1,000 good bond on the criminal trespass. Judge, this incident took place on June 6th of this year. Officers responded to the Hadley Apartments located at 770 Juniper Street. Upon arrival, they met with the property manager who advised that there was a trespasser in the apartment who denied her entry. The apartment should have been vacant. The officers were eventually able to gain access to the apartment. And when they gained access to the apartment, there were several stolen items, including some items that were suspected to be involved in a burglary of someone's home. The state is asking that the bond remain as set, just given his extensive criminal history. My pretrial said he has 50 cycles. I'm showing 52 cycles. Regardless, he does have several prior convictions for criminal trespass and several felonies. I believe the probation case that is currently probation violation case that's currently open. There is an underlying criminal trespass in that case as well.
Ms. Vigiletti?
Yes, Your Honor. Mr. Mays is from here in Atlanta. I've recently updated his information in Odyssey with his current address. He does have a stable place where he can receive mail. He stays with his Aunt Robin. I went back similarly and watched the first appearance to figure out why the bond was set. And I wanted to raise bond again today because a huge consideration was not discussed at his first appearance. And that is the fact that Mr. Mays is on felony probation for an incident out of Douglasville, that he had a little bit of trouble early on in probation getting to Douglasville, and he has recently had it transferred to Fulton County. And he was able to tell me when I went to talk to him, he reports to 276 Memorial Drive, and he's just very, very concerned because he is on track with his felony probation now. And he is supposed to report on the 18th and complete an MAGT at that time. And so given that he's already under supervision, he's already going to be undergoing an MAGT, he's very concerned with keeping up, of course, with felony probation, as he does have, that is, 8 more years. It does seem that his time would be better spent complying with those requirements. He does adamantly deny these charges. I don't want to get too deep into the facts. I know that's not what we're here for today, but he does tell me he was an invited guest to the apartment and that he had no reason to know the person who invited him was a squatter. And so he does want an opportunity to present his defense. He was left holding the responsibility for something someone else did. He was working at True Food Kitchen where he had just started. He'll likely not be able to come back because of being in custody, but he has experience in kitchens, and as a bartender, he's highly employable. And just after, the work he did to get his probation transferred and get on the right track with that, he just wants to stay on track, Your Honor. And so just because these circumstances weren't discussed at first appearance, we wanted to bring that to the court's attention and ask for a signature bond this morning.
Has he already been to address the probation violation?
Yes, Your Honor. The probation violation issue is not holding him, and he tells me that he's reporting as he should be and he did provide me that Memorial Drive address, which is correct.
Okay, so you're telling me that nothing is holding him except for this $1,000 good bond?
Yes, Your Honor.
Okay, given that he's worked out the probation issue, I will convert the good bond to a $5,000 SOB through pretrial level 2 with all of the other conditions that were in the original bond.
Okay, thank you, Your Honor.
All right, good luck to you, Mr. Mays.
Next, we can go to position number 14 and 15, DeMarcus Love.
I do need to wait on that for a few minutes and try to reach family.
Okay, we can go to Mr. Davis. He is position number 2.
Your Honor, Mr. Davis, I'm going to file a waiver of presence and arraignment. We're not addressing bond, so there's no need for him to appear at all.
Okay, Mr. Davis, your case will be returned to the division judge and you'll get notification of your next hearing date, sir.
Aye.
Yeah, come back there. We can go to
What do we
medical.
got next?
On the probation calendar, we can go to position 1 and 2, Mr. Beckhart.
Good morning, Mr. Beckhart. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Let's see, Officer Allen.
Your Honor, the defendant was sentenced for the charge of simple battery, as well as theft by taking. He was required to do 12 months of probation, pay a probation supervision fee, complete 6 weeks of anger management counseling, no further contact with the victim, Curtis Fisher, and complete an anti-theft course. Your Honor, he has failed to provide our office with the completion of the anger management course, as well as the shoplifting course. Your Honor, he has been in custody since June the 13th. 2024 is 287 days remaining on his case. Your Honor, he does have enough time to complete the remaining conditions. We ask that he be allowed to continue on probation.
Mr. McClain.
Your Honor, Mr. Bighart has with him documents which show that on December the 4th of this past fall, he went into custody in DeKalb jail for a few days and then was transferred on December 13th of this past fall He was transferred from the DeKalb jail to the Gwinnett jail, and he has been in continuous custody since 12/4/23. So he came to us from Gwinnett. So the actual 287 will be a different number when all that's calculated. And the other question is, was there a tolling order? So I explained to him that because sometimes documents need to be looked up, that's why people are given 3 business days to prepare for their probation hearings, and that he could waive that 3 days or not waive the 3 days. But if we need to look up whether or not there was a tolling order, we would need to see what the tolling order says, if it exists.
Your Honor, the tolling order does exist.
Okay,
Judge Taylor signed the tolling order
very good.
on September 22nd, 2023. And Your Honor, also, according to, give me 1 second.
Hello, can you guys hear me?
Yes, ma'am.
I'm so sorry. I was just trying to make sure I'm in the right courtroom.
Okay, well, let me finish with this hearing and then I will address you and I'll let you know whether or not you are, okay? So as soon as I'm done with this hearing, Ms. Kim, I believe that you're the one speaking. I'll come back to you, okay?
Okay, thank you. I just know my court started at 11 and I cannot miss it.
Okay, we have something that starts at 11 also, so I'll be right with you, ma'am.
Okay, thank you.
You're welcome.
And also, Your Honor, the defendant was sentenced to probation July the 20th. He was released from Fulton County with no holds on July the 21st, 2023. And after that, Your Honor, our office reached out to the defendant on August the 10th, and with no response, but a message was left for him to report August the 15th. On August the 15th, another message was left for him to report August the 22nd, Your Honor. And then we actually sent out what we call a failure to report letter advising the defendant to come in on September the 7th, 2023.
Okay.
Of those facts and matters, we have no doubt. The September 22nd date is the date I needed to calculate from September 22nd, when the tolling order went into effect, until December 4th. Those would be the days he has left on probation, because once you're in custody inside the state, the tolling order stops. So he would have October, November, 4 days in December, about 8 days in September, 8 and 4 and 60. Let's see, about 70-something days. And so I've advised him that if he's got 70-something days left on probation, not 287, even if he has 70-something days on probation, it's not that hard to knock out an anti-theft course. Let's get her done.
Well, he has 6 weeks of anger management and an anti-theft course, is my understanding.
Anger management is very good.
Okay. So I'm going to reinstate him and let you all work out the days after the day's hearing. So he'll be reinstated, and he needs to get right on the anger management and the anti-theft class, and he's to report as directed.
Your Honor, may I also add, since we are discussing, or we're going to discuss the time remaining on the case, since Mr. McClain stated that he had a shorter amount of time, can I ask the court to set a deadline for the defendant to enroll within a week of being released from custody, since we're questioning how much time is remaining on his case?
Of course, Officer Allen. So you're to, I think a week is a good amount of time to get enrolled in the anger management, and also the theft class shouldn't take that long. So you need to start both of those within the next week of getting.
Question, Your Honor, when you get a chance.
What is your question now? He's got a chance.
Hey, can I ask a question? I'm going to interrupt you.
Ask Mr. McClain there, and he will see if it's appropriate for.
Basically, I'm only shooting at 78 days. I've been, I got 288 days, and I guess I got 78 days. If I served 10 months out of 12 months probation now in jail.
I've stated that.
So he said, we gotta kind of figure it out, Your Honor. So
We figured it out.
So I have 78 days left. That's what's going on.
That's my understanding.
All right, that's good. All right. That's good.
Okay, all right, good luck to you, Mr. Bighart.
Thank you so much, Your Honor. I appreciate it.
You're welcome.
Probation 7 and 8, number 7 and number 8.
Okay, let me go back to Ms. Kim right there. Ms. Kim, are you with me?
Yes, sir, I am.
Okay, what's your full name?
Patience Holland. Thank you so much.
Ms. Holland, and what calendar are you supposed to be on?
11 o'clock today.
Your Honor, she's on the DB calendar.
Okay, all right, so you'll be on one of my calendars, so as soon as I'm done with this court, I'll address you, Ms. Kim.
Thank you.
You're welcome.
Your Honor, just briefly, I want to confirm, Ms. Holland's case is a conflict case, so we cannot assist with that. I did send an email, but it was yesterday afternoon, so I just wanted to make sure the court was aware.
Okay, and let's see. Do we still have Ms. McLeod on? I see her there. Ms. McLeod, are you still with me? Can we give Ms. McLeod a call, please? And see if she can assist with Ms. Holland's case this morning?
Yes, Your Honor.
Thank you. I appreciate it, Ms. Champion. Okay, we'll be with you, Ms. Holland. I'll see if we can get someone to address your case.
Thank you so much.
You're welcome. Okay, who do we have next?
CDC position 25, Miss Shelton.
Okay, so this is going to be a waiver.
Yes, Your Honor. And I did, I'm sorry, what solicitor is handling this case? I did reach out to Ms. Falk because this is a bind over case. It doesn't appear to be holding her in the jail, but I did just want to assure that I believe she has a bond on it, but because I don't have any of the bind over paperwork, I don't have any proof she does. So I just wanted to make sure that we didn't need to address bond today.
It's my case, and let me pull it up because I'm not sure.
Okay.
Your Honor, I believe they were ready to address positions 7 and 8 on the probation calendar. If you want to go to that one first, so I can look this up.
And that's my case as well, Your Honor.
And Ms. Vigilante, when you finish that one, I have you add on 2.
No, we're gonna do probation number 7 and 8 because I said it first.
Oh,
Right.
no, after I said after. I said after. Thank you.
Okay, let's see. Mr. Roth? Is that a medical booth, Mr. Ruth? Excuse me. Yes, sir. Good morning. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video this morning?
Yes, sir.
Thank you, Mr. Ruth. Officer Allen?
Your Honor, the defendant was sentenced to probation for obstruction of a law enforcement officer. The defendant was defendant was ordered to do 12 months, complete 12 months of probation, complete 40 hours of community service, as well as the Operation 21 and pay probation supervision fees. Defendant, he failed to appear before Judge Besson on October 25th, 2023. He's failed to provide our office with completion of community service official letter. He did, in fact, provide us with an official timesheet, just not the letter. He's failed to provide us with the completion of the Operation 21. Your Honor, he has been in custody since June the 25th, 2024. It is 91 days remaining on his case. Your Honor, probation recommends that his case be time served.
Any objection to that, Ms. Vigiletti?
No, Judge, and I'll just, reiterate, Mr. Ruth did do the community service, but there was a mistake in how he reported. Similarly, he tells me he did take the Operation 21 class, but they wouldn't, release the certificate to him because he didn't have the money to pay for the class. And so this is a situation of imperfectly completing probation.
Okay. Time served. Good luck to you, Mr. Ruth.
Thank you.
Okay, so
And Your Honor, for position 25, Latrice Shelton, I am showing that she had a first appearance in the Municipal Court of Union City and was given an OR bond on June 23rd, 2023. So I don't believe we need to address bond in that case.
Okay, wonderful.
We can go to position number. Where's my probation? 3 and 4, no, just position 3, Mr. Cart Frederick, aka Frederick Hart.
on the probation revocation calendar,
Yes.
positions 3 and 4, Frederick Hart. Okay, yes, good morning, Mr. Hart. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Your Honor, he's hard of hearing.
Oh, okay, we're doing this by video. Is that okay with you, Mr. Hart?
Yes.
Okay. Where are we with Mr. Hart's case, Officer Allen?
Your Honor, he was sentenced for the charge of shoplifting. He was required to complete a shoplifting course as well as stay away from the victim in the case. He has failed to provide our office with the completion of the shoplifting course. He has been in custody since June 29th, 2024. It's only 56 days remaining on his case. At this time, probation recommends his case be time served.
Any objection to that? Mr.
No, Your
McLean?
Honor, the only confusing thing, I'll speak up for him to hear me. The only confusing thing to me is that he says that he went to court yesterday. I don't doubt him. He says he believes his probation matters were taken care of in another court yesterday. This was yesterday afternoon when I talked to him, so I haven't had time to look up any such thing. But the time served would be consistent with the idea. He says they terminated my probations yesterday. I said, well, we got to look that up. But it looks like they're going to do it tomorrow anyway. So
he went to court. He did go to court he had 2 cases in our system. Judge Morrison heard the her case, but this particular case was not heard on yesterday. So that's where the confusion.
that clarifies everything. Thank you. But no objection to time served, Your Honor. Absolutely not.
Okay, time served. Good luck to you, sir. Ms. McLeod, thank you for rejoining us. I have a Miss Patience Holland on the DV bench warrant calendar that needs a conflict attorney. Are you able to speak with her and represent her for me? Okay, Miss Holland, can you activate your camera for me?
Yes, I'm here.
I'm going to place you into a breakout room. This is Attorney McLeod so that you can discuss your case with her, okay?
Yes, sir.
Okay, so if we can place Miss Holland and Ms. McLeod into a breakout room, please. All right, who do we have next?
Add on to ACDC, Miss Alicia Ray. I'm sorry, probation 5. She has 5 and 6, Alicia Ray.
Yes, good morning, Ms. Ray. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, and good morning.
Good morning, ma'am. Thank you. Where are we with Ms. Ray's case?
Your Honor, she was sentenced to probation for the charge of battery, family violence, and criminal trespass, as well as theft by taking. She was required to report for 12 months, complete 24 weeks of domestic violence counseling, no further contact with Regina Sayas, and pay probation supervision fees. She's never reported to our office. Your Honor, she has failed to provide our office with the completion of the domestic violence course. It's only 85 days remaining on her case. Your Honor, she has been in custody since June 12, 2024. Your Honor, because of the time frame and remaining on her case, she does not have enough time to complete the domestic violence course. Probation recommends that her balance be revoked.
What's the balance again?
It's 85 days remaining on her case. And she has been in custody since June of 12th.
And June 12th. So that's what, just about 30 days?
Yes, Judge.
Yeah.
Yes, Ms. Vigilante.
We're just requesting this morning, Your Honor, that we consider this time served because she has been in custody for 30 days. Ms. Ray is a single mom of 2 children. The oldest is 12, the youngest is 3. Her children are currently with her mother, but that is causing a significant hardship on her mother, who works at UPS and is missing shifts, for the past months, trying to make sure the kids are cared for. Ms. Ray has been working at Wendy's for some time, although she's sure she's lost her job now that she is has been in custody for the past 30 days, but she is employable. She will get back out there and get back to work. The reason that she fell off of her probation, Your Honor, she moved shortly after she was released from custody. She did have a baby, who was just over a year old at the time, and got caught up. Wasn't getting anything in the mail because she moved, got caught up in life. And then, of course, as you know, the longer you don't show up for something, we see it all the time. People become afraid to show up at all. And so because she is a single mom of 2 kids, this was a bad mistake that did fester, but she's been in custody for 30 days. So what we're really talking about is, assuming the jail would give double credit on the 85 days, whether or not 13 more days in custody would have a significant impact on her. And while it would significantly harm her children and her mother, I don't know that it would necessarily, serve anything for Ms. Ray to serve the additional time. So we're just requesting that Your Honor consider the 30 days sufficient to close the case this morning.
Ms. Ray, if you go missing, people have compassion for you if you try to stay in touch, yeah, everyone goes through things, but if you stay in touch with people and let them know what you're going through with, they can be much more know that you're going and make note of it. But if you just go missing, at some point in time it's going to catch up with you. It's just not going to go away. You understand what I'm saying? So that makes it even harder on you, because you've got something that's hanging over your head all the time. I don't feel right in having her just not do anything. Ms. Vigilante. I mean, she didn't do anything. She didn't even try to do the domestic violence classes. She didn't pay the fee. She didn't report.
Oh, I didn't even know about the.
Well, yes, yeah, okay. I mean, if you tell me you didn't know, then I know that that's not correct because you always know when you're on probation that you're on probation and what you're on for probation for. So it's this whole I didn't know that even makes it worse for me. Okay. She's got another 85 days. I want her to do something. Okay. I'm going to require that she does, I'm going to reinstate her and require that she does 30 hours of community service. So at least she's doing something. If she doesn't do the community service and if she doesn't start doing the community service as soon as she gets out and report on a weekly basis to probation, when she comes back, I'm going to revoke the balance. If she misses any time from reporting or she does not start the community service within a week of her getting out, bring her back, Officer Allen. Let's make it sure there's a time that's before me, and I'm going to revoke the balance. I want her to do something.
Understood, Your Honor.
All right, so 30 hours of community service. Once she does that, we'll close the case.
Also, Your Honor, Ms. Vigilante, can you make sure that you give her our address and as well as send that her information to us?
Yeah, absolutely. I did not, I don't have it. I have to collect it. Deputy Milton, I'll give you a call once we're done here. Thank you.
Okay, and Your Honor, that concludes my business. May I be excused?
Yes, thank you, Officer. We'll see you next time.
All right. Can we finish up? Go ahead. Position 25, Ms. Shelton.
Yes, Ms. Shelton, a waiver was filed. You'll get notification of your next hearing date, ma'am. It's my understanding that this is not holding you in custody. Is that correct, Ms.
Yes,
Angeletti?
yes, Judge. So that's what was confirmed this morning, Ms. Shelton. You do have the bond on this, so it's not holding you, so we're all set.
Okay, good luck to you, Ms. Shelton.
Thank you, Your Honor.
Okay, I'll see you this afternoon. Okay, have a good rest of the morning. Who do we have next?
I guess you could do,
I believe this is Wendell Red Medical.
Position number 23, Mr. Redding.
And this is gonna be a waiver.
Yes, Your Honor, Mr. Redden did want to be present. We would like to enter a not guilty plea. We are working with social work on some assistance, some housing and recovery assistance, but are not prepared to make a bond argument today just because we don't have that in place.
Okay. As such, Mr. Redding, your case will be returned to the division judge and you'll get notification of your next hearing date, sir. Good luck to you.
sir.
Thank you, Judge.
Okay. Who do we have next?
Judge, may I ask, I know positions 26 and 27, Mr. Valladares needs a Spanish interpreter. I was wondering if that would be possible today.
No, we was not able to get a Spanish interpreter.
Okay, and because that was going to be, oh, but you know what? He has an open felony, so if we could just reset that case, I think that would be fine.
Okay, when would you like to reset this? A week out?
Sure, sounds good.
Okay, so that would be on the 18th.
Okay, thank you.
Okay.
Vegiletti, I will put it in the chat for you.
Oh, wonderful. Thank you so much.
We can go to position 14 and 15, Mr. Damarcus Lowe.
And this is going to be
Waiver of arraignment, both cases. Bond request as to one of the cases, Your Honor.
which case would that be?
One of the cases has a surety bond and one of the cases has a cash bond. That is the fourth and last line on his booking screen called 24 CR 004195E. Not 96, but 95E. 96 is the other one. So on the cash bond, we'd like to ask the court to simply consider converting that to a surety bond. And that would render his total on both bonds to be 2 + 1 + 4. It'd be $4,500 total surety bond, which we believe is substantial enough to meet the purposes of bonds.
Okay, I'm gonna have to start from the beginning here. So you all tell me on position number 14, the battery family violence, is there a bond on that case? And if so, what is it?
Yes, Your Honor. So I can make this a little more simple. There's two incidents that happened chronologically. Position 15 happened first. Judge Mincy gave a $3,000 good bond on that case, $2,500 on the battery, $1,000 on the battery of a pregnant woman. The second case chronologically is position 14, and the bond in that case, same victim. The bond in that case was a $2,500 cash bond. It's my understanding Mr. McLean's asking that the position 14 bond be reconsidered from the cash bond to convert it to a surety bond.
Correct.
Okay, and let's see who.
And Your Honor, I can. He only has one other prior arrest. It's a 2022 shoplifting. And then there are these two cases. I would like to briefly go into the facts of both cases. I'll be quick just because I think it's important for the context. So position.
I'm sorry, Ms. Desiano. Before you do that, I just want to make sure that did the same judge give the cash bond as gave the other bond for position 15?
Yes, so this was my case from SEA, I remember it well. So this case, the arrest happened at the same time. The first incident happened in August of last year. The second incident happened June 27th of this year. He was arrested on June 27th and he had an outstanding warrant from the previous. So both of these cases were heard at the same time on the SEA calendar in June.
Okay, thank you, Mr. Esiano. Go ahead.
Okay, so, I'm sorry, Mr. Go ahead.
Is it correct that he didn't have an arrest on the first one, right? He found out about having a warrant on the first one when he was arrested on the second one a year later?
I don't know whether he knew if he had a warrant or not, but the arrest for the second incident, he was booked on the previous warrant and arrested for both cases on the same day in June.
Right. No, he's simply stating he didn't know about the first warrant. It just came upon him. It looked like one big case, but with two different incident allegations. He's going to go live at his auntie's house, Barbara.
Hold on, Mr. McClain. I don't think Mr. Esiano was done yet. Were you, Mr. Esiano?
No, Your Honor, I'll just go briefly. So the first incident happened in August of last year. It is the same victim. It's his child's mother. Her name's Arnesia Blue. The first incident, she was 3 months pregnant with that child at the time. She called the police. She told him that her boyfriend and she had a verbal argument. She advised him that she was not feeling well due to her pregnancy, and he headbutted her, grabbed her by the stomach, and then threw her across the bed. The victim had a scratch on her wrist as a result. And then, of course, because that was the first incident, Judge Mincy did just a regular surety bond on that case, $3,000. The second case happened in June at the Children's Scottish Rite Hospital. The victim, Miss Blue, was there with the defendant and their child who was hospitalized. And I recall this case well because the victim, we weren't able to get a hold of her prior to the SEA hearing, and then she did show up on the Zoom. So I did examine her for probably about 10 minutes about what happened and all of that. She did testify that I believe, if I recall, the argument started because she asked him to feed the child a bottle and he got upset. She begged him not to cause a scene in the hospital and punched her in the face and caused a bloody nose in front of several witnesses at the hospital. So while she was testifying, I'd asked her questions about prior domestic violence, not including these cases. She did, and I believe she said that she wanted contact. However, she did say that these parties have an extensive domestic violence history, that he has injured her multiple times, and not just hit her and injured her, and she hasn't called the police. So in light of that, Judge Mincy did order no contact over the victim's wishes. Obviously this, I won't say, the state does object to a reduction in bond. However, I did ask Judge Mincy at that hearing that if she wasn't inclined to do a cash bond on the second case, that the state would be requesting a $5,000 surety bond instead. I will say the same thing today. I have no objection to a $5,000 surety bond if they want to convert it from the cash bond to the $5,000 surety bond. However, based on the Ayala factors, the defendant is a clear danger to this victim. He has a high risk for offending based on the victim's testimony and several arrests considering between these two parties. And she was especially vulnerable in both cases here, Your Honor. First, she was pregnant and he grabbed her by the stomach and threw her down. The second, she was caring to their sick child in a hospital. And I believe that the reason for the second incident was very minor. She asked for his help in assisting with feeding the child and he punched her in the face. So the state would just ask that you consider the context of both cases when considering reducing or changing the bond in the second case. And again, the state would have no objection to converting that to a $5,000 surety bond if the court's inclined.
That's actually within the range of what is reasonable for what we're asking, Your Honor. Obviously, we're not trying the case today, and he is innocent until proven guilty and has the presumption of innocence. The $5,000 surety bond would suffice.
And Judge, I just clear that we are, the state is still requesting that there is no contact whatsoever with Miss Blue.
They're not going to be living together. They're not going to be talking to each other.
Excuse me?
Yes, Ms. Blue. If you would like to address the court, you'll have to activate your camera for me.
Okay, yes.
Hi.
Okay, good morning, ma'am. Can you raise your right hand for me? The other hand?
Oh, sorry.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, good. What would you like to tell the court, Ms. Blue?
I would like to say that DeMarcus, he's not any harm to me, and that actually we need him at home because he has responsibilities at home, and he's no harm to me, and I think that he has learned his lesson from sitting in there this time that he has sat in there. And I asked that if we could do some type of counseling or something, something like that. And yeah, he has responsibilities at home and he has to get back to work. So I was asking if we could do anything about the cash bond.
Okay, well, I'm gonna do something about the cash bond, but I'm still not gonna have him around you and your children at the present time, okay? I understand he has a responsibility to those children also. He has a responsibility, if you have been saying that that he has been laying his hands on you, okay? And that's my understanding from what the state is alleging here and what you have called the police and said in the past also. You've got those children that you both have to have a bigger responsibility for, and they don't need to be in that type of environment. So until you all work this out, he's not to have any contact with you in regards to that. Okay.
I have a question. What could we do for him to be able to, so for us to show you, you know, that that's not happening anymore, and for him to be able to be back around me and his child?
Okay, well, you can discuss that later with the solicitor's office as the case goes forward. But as we stand now, and this is just a bond hearing, he's not to have any further contact with you.
Okay.
I am so in that regard, if I do convert the cash bond to a surety bond, and given that the state has no objection to a $5,000 surety bond, in addition to the stay away, the no further contact, I am going to require that he begin the FVIP program, Mr. McLeod. And if he begins the FVIP program, maybe you can make a modification at some later date. If he starts that program now, having contact with Ms. Blue. I don't like keeping parents away from their children, so I'm going to have him have third-party transfer of any minor children for visitation, and no drugs, alcohol, weapons while out on bond. So in addition to converting that bond, there will also be the addition of the FVIP.
Your Honor, the only question I have about that is this. I know that the FVIP, which is also frequently called DVIP, is a national standardized program in which there is no blaming of the alleged victim. If it is participatory and if he has to actually respond with essays, he would be in danger of making admissions. If he has to write about what happened and the case is not yet adjudicated, he couldn't really participate correctly. If it is simply him receiving information from lecturing and from things like that, but if it's a workbook type thing where he has to participate and admit things prior to trial, that couldn't happen.
Okay, well, it's my understanding that FVIP is quite often a requirement of having someone on pretrial release. So I'm going to order that in this case. And if he doesn't, I'm given Ms. Blue's desire, I'm giving him the opportunity to do something to maybe get his family back back together prior to any further hearings on this. If he does plead guilty, and I don't know if he will or not in the future, then he will have, that will go very far in showing the court that that he's already done that program or participated in something. So if he wants to get back with his family as she requests and as he possibly does, then I don't feel comfortable with just letting him out around them without him doing some type of family violence intervention. So
Understood, John. Yes.
And Your Honor, I don't
Yes.
recall ever seeing results from someone's records from any of their DVIP courses. And it's my understanding, at least when I was in private practice, when I did defense, it was a class and you had to attend the class for several hours. I don't believe there's any written work associated with it, but regardless, those records and things are not something that the state receives.
Okay. Thank you, Ms. Essiano. All right, so we'll make those modifications, or you make those modifications, Mr. McLean, get them to us, and we'll get them signed and entered.
Okay, excuse me, Judge, that's just only on amended bond on position 14. Position 15 remains the same, correct?
That's correct. Yes, Ms. Grace.
And Ms. Disiano, can I have the address for the stay away, please?
So there was a little bit of confusion at the hearing. So I'd asked the victim if she still lived because there's two incident locations. One of them's a hospital and one of them is an address. It was 85 Delmcore Drive. It's the stay away that's in position 15. I did ask the victim if she still lived there. She said no, but then the defendant had listed that 85 Delmcore Drive on when he was booked into the jail. So I believe the way we left it was Judge Mincy ordered a stay away from the 85 Delmcore Drive. I believe she also did the stay away from the hospital. I don't think I even asked for that. And then we also added, because there was some confusion about her address, we just put stay away from the victim's address. So I don't know if while she's on the line, if we can ask her, but I did try to figure that out the last hearing and there was some confusion.
It would be good to pin that down. I think that what I had was not a Downford, but a Delmore, Delmoor Road. I think we're talking about the same place, but I think that he lives there, but not her.
Well, it was my understanding they lived together for the first incident, but is Miss Blue still on the line?
She is.
Yes, I am.
Miss Blue, can you just give the court the address that you live at?
My address is 2186 Pryor Road.
Pryor, Pryor.
Mm-hmm.
And that's Atlanta?
Yeah, Atlanta, Georgia.
Good.
Okay, we have everything we need?
Okay.
All right, stay away from Pryor. What was the number?
It's 2186 Pryor Road, Atlanta.
Got it. Thank you.
Mm-hmm.
Thank you, Judge.
Okay. Let's see, on the SAP calendar, I have that we still have position number 13 that we need to address.
Oh, Your Honor, I'm sorry, before we continue, so the last bond order had to stay away from the 85 Delmcore, whatever the address is. Does the victim not live there at all? Miss, do you live at the 85? Do you ever go to the 85 Delmore Drive or Road or whatever the address is?
No.
Do you have any reason to go back there?
No.
Okay, then we would just do the stay away from the 2186 Pryor Road.
And that's what I have on both cases. Thank you.
Okay, thanks.
Do we need to keep a stay away from Scottish Rite? That sounds like it was a temporary hospitalization.
I didn't ask for that.
Okay, no, just stay away from the residents.
Thank you. Very good.
Okay, and someone was asking about Benjamin Sawyer. Mr. Sawyer apparently pled not guilty on June 27th, so he's not going to be in this court this morning. Who's ever asking about Mr. Sawyer?
Excuse me?
Yes, ma'am. He's not in this court this morning. If you were asking about Benjamin Sawyer.
No, sir. I'm still, it's Arnasia Blue asking about DeMarcus.
Okay, we're done, Miss Blue.
Okay.
All right, have a good day,
No,
ma'am.
ma'am, this is, hello, Your Honor.
Yes, ma'am.
Yes. Your Honor.
Yes, ma'am.
Hi, this is Benjamin Sawyer's mother. Sorry.
Okay, yes,
I got a link that's, yes, I got a link and a call yesterday saying that he was gonna be in the court today.
He's not here today. It's my understanding that he pled not guilty on June 27th, and his case, those are normally reset and sent back to the division judge. So he's not with us this morning, ma'am.
When you say set back to the division judge, what is that?
He'll get notification of his next hearing date.
Okay, thank you, Your Honor.
You're welcome, ma'am. Have a good day.
You as well.
Thank you. And are we gonna have position 13 Kingsley with us this morning?
Your Honor, we were not able to interview him yesterday. He's in the POU, and I believe that's going to be Tuesday at the earliest before we can do anything at all.
Okay, so you're asking for a reset. Is that correct?
Well, I think I just haven't met him, so I'm sure that that's the only.
Okay, so
Yeah.
we'll reset him for 1 week? Or you want him to reset for Tuesday?
Tuesday if possible. He's being offered a recommendation to the court of time served.
Okay, all right, just tell me what you want, Mr. McLean. So we'll reset him for Tuesday, the 16th.
Very good.
Okay,
Thank you.
so it's my understanding that that completes the SAP calendar, is that right?
Yes, Your Honor.
All right. So we still have the DV calendar, 11 o'clock. We still have the competency calendar. I want to release everyone that doesn't need to be here for those calendars. So if we can go over the SAP calendar, if there are no objections, before I move on to the next calendars, so that those that don't have to stay with me can be released. Is that agreeable with everyone?
Yes, Judge.
Okay, thank you. So Ms. Grace,
Yes, sir.
when you're ready, can we go over the SAP calendar?
Yes, sir.
Okay,
Position number 1, reset further notice, defendant was released. Position number 2, reset jail jury. Position number 3, reset further notice with an amended bond order of $5,000. Reset 4 was a plea, excuse me. Position number 4 was a plea. Position number 5, reset further notice. Position number 6, reset further notice with an amended bond order, $3,000 pretrial. Position number 7, reset jail jury. Position number 8 was a plea. Position number 9, reset 8/22 competency calendar. Position number 10, reset further notice with an amended bond order, $5,000 pretrial. Position number 11, reset 7/16 SAP. Position number 12 was a plea. Position number 13, reset 7/16 SAP. Position number 14 and 15, reset jail jury. Position number 16, reset further notice, amended 5,000 SOB bond. Position number 17, amended bond order, reset further notice, 5,000 pretrial. Position number 18, reset jail jury. Position number 19 was transfer going to MMC court. Position number 20 and 21, reset 7/16 SAP calendar. Position number 22, reset jail jury. 23, reset jail jury. 24, reset jail jury. 25, reset jail jury. 26 and 27, reset 7/18 SAP calendar. Any questions, concerns, or comments?
Can we do the add-on calendar?
Oh, I'm sorry. In the add-on calendar, position number 1, reset further notice with an amended pretrial $15,000 bond. Position number 2, reset further notice $20,000 amended pretrial bond. And position 3 and 4 was please.
Okay, any questions or concerns about any of that? Okay, next, let me take up the DV bench warrant calendar. The first on the calendar is Patience Holland. Ms. McLeod, have you had an opportunity to speak with Ms. Holland about her case?
Yes, Your Honor, I have.
Okay, and who is representing for the state?
It's my case, Judge. I'm showing that she FTA'd a plea and arraignment calendar, Judge Richardson, on July 1st of this year. The notice was mailed on June 4th to 400 West Peachtree Street. It wasn't returned. However, I did Google that address. It does appear to be like a condo building, and the address didn't have a unit number, so that may have been the issue.
Okay, thank you, Mr. Estiano. Ms. McLeod?
I'm so sorry, Your Honor. I'm wondering if, in the interest of a
I'm fine.
I can speak to Mr. Lara Murillo while we're addressing this other case, just so I'm not holding up the court.
Okay, thank you.
I'll
Yes, so,
open Zoom from my phone, and maybe we should be put in a breakout room.
okay.
Okay, thank you so much.
Did you get that, Ms. Champion?
No, so who would she need to be in a breakout room with?
Let's see, Mr. Jose Laura Murillo.
Is he on the Zoom panel?
He was on the line. I saw him there a moment ago.
I'm not seeing him at this time.
Right. You want to give him do you have his number?
I do, Judge. I'll give him a call.
Okay, have him log back on for us.
Who is
Okay.
representing position number 13, Mr. Kingsley?
Mr. Kingsley's case, so, Mr. McCain, are you still there?
They bought him out.
Mr. McLean,
Yes, Your Honor.
this is Mr. Kingsley here. Do you still want me to reset this until Tuesday, or do you want to speak with him?
Your Honor, there's only one person behind me in the benches. If he could be put temporarily for about 5 minutes over here, I could do a breakout with him and ask him if he wants that offer of recommendation to the court. I think that would be efficient if we went ahead and took our opportunity now.
Okay, so we can place courtroom 2 and medical into a breakout room, please. Thank you. And I'm sorry, Ms. McLeod, I interrupted you.
Yes, Your Honor, I was saying that this was the situation where my client did not get the notice. She tells me that she had updated her address with the post office, but didn't realize that she was supposed to update it with the court. It was a dual arrest situation, Your Honor, and the father of her child still lives at that address. And she said she thought he would have informed her when he received notice, even if she didn't receive it at her new address, but he did not. She found out perhaps 2 days later. And of course, she tried to get a reset. And this came up because she was interviewing for a new job. She works in healthcare, Your Honor, as an administrator in healthcare, and this is an issue for her. She doesn't really have any record or anything. She has a good address, which she has provided me with, Your Honor. So I would ask the court to consider setting aside the failure to appear warrant.
All right, so you do have a good address that you can update the court. Is that correct?
Yes, Your Honor, I do.
Okay.
And Judge, I'm sorry, I went down once I found out about the warrant, and I got this paperwork, and I also updated the address there.
Okay, all right, so anytime you move, Ms. Holland, you're gonna have to make sure the first thing you do is to update the court with your new address. So I typically give people one chance. You've had your one chance this time. If you miss court again, I'm not gonna set it aside, but I'll set it aside this time, okay?
Okay, thank you so much.
All right. Thank you. I appreciate you helping us out with that, Ms. McLeod, and Ms. Holland, you have a good rest of your day.
You're welcome, Your Honor.
So is there any way like I can get a form of that? Because I don't want to be driving because I have to run now and get pulled
Okay,
over. And
so what'll happen, Ms. Holland, is that Ms. McLeod will get me the set aside order. I take it that, and once I get that order, I will get it signed and I'll get it back to the clerk and it will withdraw that warrant, okay?
okay, do you know about how long that'll take?
Well, it will at least take me till this afternoon, so don't get pulled over before this afternoon.
Okay.
All right, we'll get it done as quickly as we can. Thank you.
So
All right.
will the lady, so I'm sorry, will the lady notify me or?
Yes, I will notify you at the address. You provided me with your contact information.
Okay, got you. Thank you so much, guys. Have a great day.
You too. Thank you.
Okay, bye.
Okay. Good morning, Mr. Murphy. We still have the competency calendar to do. I guess we have to wait until courtroom 2 comes back on with us. So I will handle the last one on the SAP calendar, the state all-purpose calendar, and then we'll go into the breakout rooms for the competency calendar. Okay. All right, so we'll be in recess until courtroom 2 comes back online.
We ready?
Okay, Mr. McLean, where are we?
That's going to be a guilty plea, negotiated plea.
Okay, this is position number 13, Mr. Kingsley.
Yes, sir, Your Honor.
Yes, good morning, Mr. Kingsley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video.
Good morning, Judge.
Good morning. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can place your hand down. Thank you. Mr. Ham?
Yes, Your Honor, the state's recommendation for the sole charge of criminal trespass is 12 months to serve 30 days, credit for time served 15 days. Balance suspended to stay away from Tokyo Valentino located at 1739 Chesapeake Road.
Mr. McLean?
Your Honor, he wishes to ask the court to accept his negotiated plea. For the purposes of the plea, he stipulates to venue, which is jurisdiction, also factual basis, and also ID.
Mr. Kings, it's my understanding that in case 24 CR 004193G, you wish to plead guilty to criminal trespass. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, Your Honor.
You understand you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir. Wait, no, Your Honor.
I'll accept your plea as negotiated, Mr. Kingsley. Good luck to you, sir.
Thank you, sir.
You're welcome. Okay, did Ms. Vigiletti have an opportunity to speak with Mr. Murillo?
Yes, Your Honor.
Okay, are we ready to proceed on that? Good morning. Good morning, sir. I take it, Mr. Ham, that he missed a court date, or Ms. Desiano, that he missed a court date?
Yes, Judge, he missed a jury trial calendar, June 18th, 2024. Judge Taylor, I'm not seeing any returned mail. The address that I'm showing the notice was mailed to is 2914 Blount Street, Atlanta, Georgia, 30344.
Okay. Ms. Vigiletti?
Yes, Your Honor. So I spoke with Mr. Lara Murillo, and the problem is he does construction work. He's a traveling construction worker, and so he returned home on the 19th of June to see the notice and realize he'd missed court. He has been compliant with the no contact order. He's not seen or spoken to the alleged victim, Chelsea Newby, so no concerns there. I understand it's difficult with his job to receive mail in a timely fashion, and so we did come up with a plan while we were talking. I'm going to give him the clerk's phone number so that he can call once a week and ask at the beginning of every week if his court date is scheduled. I'll send that to him in a text. I have his cell phone number and he has mine. So I don't think this will happen again. This was a bad mistake, but I do understand that traveling construction jobs, you can be gone for weeks at a time, not getting mail. And I think we have a plan, Your Honor. We do have current contact info. He has a job, a phone number, an email address that he has provided the court. So I don't think this will happen again.
Okay, Mr. Murillo, I'm going to set this aside this one time, but if you miss court again, it won't be set aside the next time. So you need to stick with whatever plan that you've made so that you don't miss court the next time, okay?
Yes, sir. Yes, sir. Yeah, this is the last time. Yeah.
Okay, all right. Good luck to you, sir.
Okay, thank you.
Okay, let's see. Are we ready for the competency calendar?
Yes, well. Most of that was happening about throwing things out. No, it was that time.
Okay, so
Good morning, Judge. How are you?
I'm doing well. Good morning.
Good,
Let's
good.
see. Who all do we need in the breakout room?
Well, we would need to go into a breakout room, Judge, to do the competency calendar. I can try to find some space in medical records.
Can we handle Barry Gates' client first?
Well, actually, and if,
Yeah, he's right here.
Okay, so yeah, we would not need to go into breakout room in that event.
Your Honor, can we do Mr. Robert Elliott? That's Mr. Derek Gage client.
Good morning, Your Honor.
Yes, good morning, Mr. Gage. So what position is that?
I believe it's number 3, Judge. Robert Elliott. And I know The evaluation has taken place. I don't know if the court has received a report at this time. I haven't received it, but I don't know if the court has or not.
Okay, let's see, Ms. Grace, do you know whether or not we've received the report on, position number 3, Mr. Elliott's case?
I'm checking right now, Judge. No, sir, not as of yet.
Okay. So I take it we need additional time, Mr. Gage?
Yeah, if we could just reset it, Judge, for a status, and if something comes back in between, I can report back to the court and we can, if it comes back that he's competent, we can just kind of move ahead of time.
Okay. When would you
would
like to
be
reset it until?
I'm out of the state next week, so if you want to put it for perhaps, are these always on Thursdays?
Yes.
Okay, that week after, I can't imagine.
Okay.
I know Dr. Ash has done the review, so
Okay, so the 25th?
that'll work just fine. Thank you.
Okay, so we'll reset Mr. Elliott's case until July 25th.
Thank you, Judge.
Okay, thank you. I appreciate your patience this morning.
Thank you. And that concludes my business, if I may be excused.
Yes, have a good day.
Thank you, you too.
Do we need to go off the YouTube? Mr. Bartels, are you there?
Yes, Your Honor, I'm here.
No.
Yes.
Yeah, I know that we normally do this in a breakout room, so why don't